Okay, good morning. Today we are here to discuss two major burning topics. One is governor's role in hung assembly. Although topic is given to you constitutional position and contemporary issues. So contemporary issue actually is related to hung assembly. And then second topic is public interest litigation, tool for justice or judicial overreach. This one also is very burning because 9 judges constitutional bench dealing with Sabrimala case, and almost all judges are against the PIL. In fact, the issue of Sabrimala is sidelined, and era of PIL should continue or not, that is emerged as a main question. And in the backdrop, you will find union government through Solicitor General Tushar Mehta tried to inject one idea among judges that PIL is nothing but agenda interest litigation. So in the era of e-governance, the regime of e-governance should be winded. What will happen, God knows. But being a student, we are supposed to discuss facts. And as usual, topics are very burning. So I will request you all that don't allow yourself to be a victim of any political party, either party in power or party in opposition. So let us start with governor's role. दिस इज नॉट ए क्लास, ये क्लास नहीं है, ये आप नहीं आप ले लो. हाँ, वो बेचारे हंस रहे हैं कि केवल 2 ही लड़के को ये पढ़ा रहे हैं. इट इज इन हिंदी मीडियम. ले. Good morning. Today we are here to discuss two very burning topics. One is related to governor and and as you know, topic is given constitutional position and contemporary issues. And second one is public interest litigation, a tool for justice or overreach. I think all of you know why these two topics are chosen. One is related to election, particularly hung assembly in Tamil Nadu. And another one is related to Sabrimala hearing. 9 judges constitutional bench is hearing Sabrimala case. And judges of that bench prima facie are very strict against PIL, and Supreme Court is trying to discipline PIL. On the other hand, Union government through Solicitor General is trying to inject the idea against PIL. As per Union government, PIL is converted into agenda interest litigation. What will happen, God knows, government and judiciary will decide. But being a student of the subject constitution and polity, I think we are not supposed to be victim of any political party or agenda of any political party, either party in power or party in opposition. We will strictly stick with the facts and figures, nothing less, nothing more. So let us start with governor's constitutional position and contemporary issue, and that contemporary issue is simply hung assembly. So I will concentrate on the position of governor related to hung assembly only. When we go through the whole constitution, we find the post of governor is the most sensitive, most crucial, and most complex in nature. India has adopted a parliamentary democratic system with federalism, and the post of governor is emerged as a crucial post because of its role as a bridge between union government and the state government. Constituent Assembly after taking 2 years, 11 months, 18 days, completed its responsibility to gift this constitution that is one of the best statecraft in the world to people of this country. But it is also a matter of fact, in last 75 years, number of things are changed. Time is not static. Time change, and accordingly life of the nation also change. And when I am talking about life of the nation, social life, economic life, as well as political life. When time change, new opportunities come. And at the same time, new problems also come. Our founding fathers paid attention even to the micro aspect of all subjects. They gave attention to the minutest detail while framing the basic law of the land. But despite that, some grey areas were left out. Although this constitution inspired people of this country, it is an aspirational document. But at the same time, number of things were not anticipated by our founding fathers. In last 75 years, number of problems emerged, and with our wisdom, our political leadership, along with the support of people of this country, tried to solve those problems. But it is a matter of fact that despite massive effort, still complex issues are haunting us. And number of issues are becoming more complex and complex in nature. One of this kind of issue is discretionary power of the governor. And when we will talk about discretionary power of governor in context of hung assembly, I will classify my discussion into 4 parts. Governor into 4 parts. First one is constitutional position. Second one, contemporary issues. Third one, commissions. Recommendations. And fourth one, judiciary's judgment. In 4 parts, we will discuss. Okay? These are the 4 areas, 4 dimensions, 4 parts. I will discuss one by one. As far as constitutional provisions are concerned, all of you know India is sovereign, socialist, secular, democratic republic with parliamentary form of government in federal setup. Federalism has been declared a basic structure of Indian Constitution. As earlier I told you, in this federal setup, governor is expected to act as a bridge between union and state government. The prime responsibility, or I should say, the prime philosophical and constitutional responsibility that is given to governor of the state is to preserve, protect and defend the Constitution as per Article 159 of the Constitution. The same provision you will find for President of India also. In that way, governor is nothing but extended hand of President of India. And philosophically, President of India was not supposed to be present in every state. So Constituent Assembly created a post of governor to perform on behalf of President of India. I must clear here, perform on behalf of President of India does not mean subordinate to President of India. When we will go through article number 152 to 167, we will find different aspects of governor as far as the constitutional status and responsibilities are concerned. Constitutionally, governor is appointed by President of India, and we know that the very concept of appointment is related to merit. It means President of India is expected to appoint governor on the basis of merit. In that way, governor is not expected to be biased in favor of one party or another party. Governor is expected to perform its role as a preserver, protector and defender of the Constitution. So he is expected to be non-partisan. He is expected to be committed to Constitution itself. He is expected to be a guardian of Constitution and the law. Constitution says that although doctrine of pleasure will be applicable, but tenure of governor will be for 5 years. And we know that in 2010, Supreme Court in BP Singhal versus Union of India case categorically stated that although governor can be removed before that 5 years tenure, but when anyone will approach to court, it will be the responsibility of union government to justify and to rationalize the removal of governor before the completion of the term. So indirectly, Supreme Court also tried to defend the sanctity of the post of governor. But it is a fact that the appointment of governor itself still is a problem. Commissions came out with number of suggestions. Hardly we respect, irrespective of parties in power, hardly we respect those recommendations. But today, I will not give much more attention to that area, because contemporary issues are not related to now. It is appointment. It is related to discretionary power. As far as discretionary power of governor is concerned, you will find two major articles. Article number discretionary power, article number 163, 164. Prima facie article number 163. But 164 also deals with, to some extent, discretionary power. Apart from these two, in number of other areas, governor is allowed to take some sort of discretionary decisions, like article number 200, like article number 356. In those areas also governor can take some discretionary decisions. But these are two major areas, and out of these two, this one is the most important, 163. Governor is enjoying discretionary power. Hope all of you know that even President of India is not given any kind of discretionary power that is mentioned in the Constitution. For President of India, neither directly nor indirectly any discretionary power is not given in the Constitution. But governor is enjoying. And Constituent Assembly was very, very concerned about the discretionary power of the governor, and first time June 1949, matter came before Constituent Assembly. 1st June 1949, matter came before the Constituent Assembly. That matter was related to discretionary power. Pandit Thakur Das Bhargava, along with H.V. Kamath, Rohini Kumar Chaudhary, and number of other members, expressed apprehension. They came out with very clear apprehension that the discretion to governor would be wrong in principle. I will repeat. Thakur Das Bhargava was very clear that discretion to governor would be wrong in principle. In fact, that will be contrary to the tenets of constitutional government. If you are going with democratic constitutional government, no functionary should be given discretionary power. But in context of today, nothing wrong to say, unfortunately. Dr. Ambedkar did not respond that apprehension carefully. Dr. Ambedkar came out with a response, and he said that this provision should be retained. And it will not be changed even after a century. He was going with the provision of governor in Canadian Constitution and in Australian Constitution. He did not respond to the situation prevailing in India, or he was unable to see the nature of changing situation in future generation or in futuristic India. When we come to article number 163, if you will go through Constitution, article number 163 is all about Council of Ministers to give aid and advice to governor. There shall be a Council of Ministers. Take your seat earliest, and in my class be on time. There shall be Council of Ministers with Chief Minister as the head to give aid and advice to governor in the exercise of his function. But after that, things will change, except in so far as he is by and under this Constitution. By or under this Constitution. Under this Constitution. When you will go through Constitution, you will find, as per literature, except in so far as he is by or under this Constitution required to exercise his function or any of them in his discretion. So Article 163(1) is actually divided into two parts. One part is very clear, that governor is expected to act on the aid and advice of Council of Ministers with Chief Minister. But second part, so far as he is by or under the Constitution required to exercise his function or any of them in his discretion. This second part is giving discretionary power. But problem here is neither by or under is defined. By or under is not defined. Because nothing is given by the Constitution, nothing is under the Constitution, but how one will interpret by the Constitution or under the Constitution will be silent here, is silent here. And because of this silence, because of this constitutional silence, the issue like a hung assembly occurs. That what governor will do if there will be hung assembly, because nothing is mentioned in Constitution. And then you will find 163.2, this is in 163.1, and then you will find 163.2 there. Constitution gives much more emphasis on the discretionary role of governor. As per Constitution, if any question arises, whether any matter is or is not a matter as a respect which governor, again, is by or under this Constitution required to act in his discretion. In simple sense, which matter will come under discretion of governor? Decision of governor shall be final. So governor is actually getting some sort of provision in his own favor, like imperialist governor. Constitutional imperialism indirectly coming to hit this provision, because the decision of governor shall be final. How? The validity of anything done by governor shall not be called in question on ground that he ought or ought not to have acted in his discretion. So whatsoever governor will do, which matter will come under discretion of governor, which matter will not. Everything will be decided by governor, and that shall not be questioned. That is very important. That shall not be questioned in court of law. It will not come under judicial scrutiny. That is the major problem. And then you will find article number 164 of the Constitution. Article number 164 of the Constitution says that the chief minister shall be appointed by governor. Now question here is that if chief minister shall be appointed by governor, nothing is written in Constitution that who will be considered as a chief ministerial candidate by governor. There is no provision. Who will be chief ministerial candidate? And I will repeat, article number 163 says that matter will come under the discretion of governor. Governor will decide. So it means who will be chief ministerial candidate? particularly in hung assembly, it will be up to governor to decide. So because of these two articles, article number 163 and article number 164, governors are enjoying that kind of draconian discretionary power. And when I am using that word draconian discretionary power, I am using in context of recent controversies. And you will find later on that even judiciary is struggling to cap the discretionary power of governor, to control discretionary power of governor. So article 163 and 164, these two major provisions whatsoever given are responsible for the contemporary issue or the burning issue related to hung assembly. Governor can exercise discretion. He is appointed by President of India, but there will be a big gap. Elephant size problem is that in hung assembly, how president will perform with his discretionary power. Granville Austin, in his book, A Cornerstone of Nation, he had written that book, Cornerstone of Nation, and he came out with his opinion. He came out with his speculation. And he said that drafter of constitutions did not anticipate. That is a view of Granville Austin, that constitution drafters did not anticipate the situation in which single party, if will not get majority, what governor will do. He came out with one another reason, and that is a very serious one. Constituent Assembly had taken almost 3 years to write a constitution, 2 years, 11 months, 18 days. But all provisions related to state governments, they completed discussion in 1 day. They did not give much more time to this topic. Out of 3 years, 1 day they considered sufficient to deal with all provisions related to province. So Granville Austin said that most probably constitution makers did not anticipate the future. Anticipation was a problem. They did not anticipate when no party will come with a majority, no party will emerge as a majority party, then what will happen to governor? How governor will come out with discretion? And that's why even today we are struggling with hung assemblies. Hung assembly is what? Where no political party will emerge as a winner party. It means more than half will not be given to any. So no political party or pre-poll alliance, if will gain majority, then there will be hung assembly. And then appointment of chief minister will be the discretionary power of governor. That will come to governor's discretion. And today we are facing the same kind of thing. Now question will arise that, sir, when you are talking about the problem related to discretionary power, today, first time we are facing that kind of problem. No, not at all. My dear, you will be surprised that since 1952, we are struggling with that. 1952. Most of you will be surprised. 1952. In Madras Assembly election, that time Madras was there. Madras Assembly election, Congress got 155 out of 321. 155. And communist bloc, this one was the Congress. Communist bloc got 166. Okay. Communist bloc got what I wrote. Communist bloc got 166. Okay. That was Communist front. Governor was Sri Prakash. Sri Prakash invited Congress to form the government. Rajgopalachari was the leader. And Congress formed the government. Because Congress was the single largest party. Okay. Although Communist bloc was enjoying 166. But Sri Prakash invited Congress party to form the government. Then in 1971, we came out with another mechanism, that was a report of Committee of Governors. Report of Committee of Governors. And a report of Committee of Governors categorically stated that in the case of hung assembly, largest party will be called. Means party with maximum seat will be called. But unfortunately, it was not respected. Then you will find this one, report of Committee of governors. Okay? Recommendation, largest party. After that you will find, and hope you know, Sarkaria. Sarkaria Commission. Huh? I think all of you know. Sarkaria Commission, 1983 to 88. Sarkaria Commission said, very important from my point of view for you to understand. Sarkaria Commission said that the party or combination of parties or combination of party which command the widest support should be invited to form a government. Second point, very important. Sarkaria Commission said, it is not a business of governor to decide who will form effective government. Your duty is to form the government, not to form an effective government that will implement policies effectively. That is not your business. Form the government. And form the government after inviting party or parties having widest support. Right? In the light of these two, Sarkaria Commission came out with 4 suggestions. Suggestion number 1. In case of hung assembly, what should be done? The alliance of parties, pre-poll alliance, okay? Pre-poll alliance, they should be given first opportunity. Clear? Second, largest party. Got? The third one, post-poll. Right? But what kind of post-poll? Alliance partners must be a part of the government. Post-poll alliance, where political parties will be part of government. And fourth, this also post-poll, but parties will not be a part of the government. They will support from outside. So, first one, pre-poll alliance. Second, largest party. Third, post-poll alliance, but alliance partner must be a part of government. And fourth, post-poll alliance, but partners will not be a part of government, they will support from outside. So this will be sequential arrangement according to Sarkaria Commission. Right? Then you will find National Constitution Review Commission 2000-2002 under leadership of Venkat Chalaiya. That commission also extended support to Sarkaria Commission itself. Punchi Commission came. Punchi Commission also extended support to Sarkaria Commission. But Punchi Commission gave emphasis that governor, when doing this kind of thing, must be transparent and must protect constitutional morality and constitutionalism. It means when governor is doing anything considering own discretionary power, is not expected to be a despotic leader, is not expected to be dictator, is expected to use that discretionary power within the limit of the constitutional philosophy adopted by India. That was the Punchi Commission. These are the major commission came out with these all recommendations. Now the question is, with these all recommendations, we were supposed to address the problems related to hung assembly. But what happened in India? That Indian judiciary, to some extent without any hesitation, one can say, that Supreme Court, despite these all advices from Sarkaria Commission to National Constitution Review Commission to Punchi Commission, Sarkaria Commission 1983 to 88, then National Constitution Working of Review Commission, that was under Venkat Chalaya 2002 to 2002, and Punchi Commission. These all commissions given on recommendations, but Indian judiciary during course of time when came out did not force governor to perform accordingly. They came out with judgment, but judgments were not so crystal clear to guide or to direct governor to perform accordingly. I am taking some examples. The first case I will take, Shamsher Singh versus State of Punjab. First case, Shamsher Singh versus State of Punjab, 1974. Supreme Court said the appointment of Chief Minister is one situation in which governor has a power to exercise discretion, but it should be kept in consideration that the aim of the exercise is that the appointee should be able to govern. What it means? That when governor will use own discretionary power, he should use to choose the leader of the party or the party itself to govern, which will be in a position to govern. So again it will be up to discretion of governor. You people are sitting here and I will be given responsibility to choose out of you all, then my discretion will continue. And I will choose as per my own wish or as per my own wisdom. That was Supreme Court decision in 1974. And then you will find Supreme Court again got opportunity, and that was a very important case, SR Bombay versus Union of India, 1994. In that case, Supreme Court said that floor test will be compulsory. It means governor will not be authorized to decide majority in the lawn of Raj Bhavan, now Lok Bhavan. So governor has no authority to decide majority in Lok Bhavan itself. Governor is expected to invite the party largest or pre-poll alliance to form the government, and Council of Ministers will be duty bound to face flow test. Means assembly will be the place where majority will be decided. Governor will not decide majority. And second important thing, that governor's discretionary power shall come under judicial review. So Supreme Court in SR Bombay case clearly mentioned that whenever governor will go for discretionary power, either here or 356 or 200, that will come under judicial review. Okay? That was the judgment of Supreme Court in SR Bombay case. Then another case came in 2001. That was B.K. Kapoor versus State of Tamil Nadu. B.K. Kapoor versus State of Tamil Nadu. And Supreme Court said in 2001, Supreme Court said appointment made under such a discretionary exercise of power still remain within judicial review. It means appointment will come under judicial review. And then a very, very famous case, Rameshwar Prasad versus Union of India. I think this case some of you may know. Rameshwar Prasad versus Union of India, 2005. Very, very important case. Supreme Court categorically stated that although Constitution is silent, but it is very clear that the governor will not be immune to judicial review. Governor will not be immune to judicial review. So whenever governor will take decision will come under judicial review. But what point I want to raise, that judgments came, but these all judgments more or less either advisory in nature, or these all judgments were not proactive but reactive. That judicial review will take place. How governor should go for discretionary power, that one was the subject matter. But unfortunately, judiciary did not explain that. What happened? Former Chief Justice Supreme Court N.V. Ramanna said that constitutional morality is different from political morality. And since constitutional morality is different from political morality, so we cannot ignore post-poll alliance also. We cannot ignore post-poll alliance. And in case of Mithilesh Kumar Pandey, this is a new case, Mithilesh Kumar Pandey versus Election Commission of India, Mithilesh Kumar Pandey versus Election Commission 2014. Court categorically stated that post-poll alliance cannot be declared illegal. Post-poll alliance cannot be declared illegal. 2014. Right? It means post-poll alliance also can be considered. Right? And again in Nabam Rabia case, Nabam Rabia versus Deputy Speaker Arunachal Pradesh 2016, Supreme Court said judicial review will take place. As I told you, that everywhere Supreme Court is talking about judicial review will take place. It means governor will be allowed to go with own discretionary power and then review will take place. That will not actually solve the problem. And that's why Still we are struggling. Otherwise, we had judgments and we were supposed to go with the judgment of Supreme Court. We had commissions, recommendations, we were supposed to go with commission's recommendations. But, my dear, when you will go through the record, recent record, leave past, recent records, in 2017, Goa, then in Manipur, Congress was the majority, but governor did not invite Congress to form a government. You will find 2018 in Karnataka, Congress along with JDUS, secular, H.V. Devgowda's party, they were claiming they had majority. But governor called Yedurappa to form a government and Yedurappa resigned after some time. Then you will find again in Maharashtra, Devendra Fadnavis was given oath in early morning. He was not enjoying. And here I must clear one more thing, that it is not a matter of state government only. You will find at national level also. At national level, Atal Bihari Vajpayee in 1996 was invited to form a government. After that, H.D. Gowda, Devegowda, I.K. Gujral, they also were invited to form a government. P.V. Narasimha Rao led minority government. Manmohan Singh, the first term, UPA won minority government with outside support. So we have a history of precedents. It means governors are expected to follow the parliamentary precedents. If governors will follow, then the present problem was not very difficult to solve. I am talking about Tamil Nadu problem straightway. In Tamil Nadu, governor forgot all those things governors themselves did in past. How they had invited in Goa, in Manipur, in Karnataka, in Maharashtra. Governor was very much clear that TVK was enjoying 108 seats, effectively 107 because one seat will be vacant. So 107 seats in effective sense, 108 in principle. And number of small political parties, including Indian National Congress having 5 seats, were extending support. But governor was demanding in a writing the support of 118 members. That is not expected from governor. Because in S.R. Bombay case, it became very clear that majority will be decided only on the floor of the house, not on the floor of the governor. So governor was expected to appoint the head of the party largest, because there was no any pre-poll alliance. So single largest party it was. and it was satisfying the post poll also. So it was very easy for Rajendra V. Alekar to call TVK to form the government, right? But he did not. Lingered on. And you will find, unfortunately, as far as the political culture of this country is concerned, horse trading is not a big issue in our country. So if you will linger on, if you will not allow anyone to form the government, either horse trading will start, or you will force a state towards 356. Both will not be good for democracy healthy. So governor was supposed to invite. When we are discussing already invited, and person who was supposed to be chief minister now is chief minister. But one another thing, there was the recommendation of the commissions and the judgment of judiciary also, that within 30 days, not in 30 days, within 30 days, the party going to form a government should go for floor test, right? The governor has given only 2-3 days this time. If governor will give less time period, hope you know that who will cast vote? MLAs. So first of all, he will have to appoint pro tem speaker. Then pro tem speaker will give oath to all members, and then members will. So reasonable time also should be given. It is not a matter of 3 days or 30 days. Reasonable time should be given to anyone whosoever occupying the position. And accordingly, whosoever forming the government is expected to satisfy the floor, right? And this is expected to prevail, right? So governors forget their job or not is a difficult issue to discuss. You will find in one newspaper, Hindu, on 11th May 2026, article was published. Governor who forgot his job. We will not come out with that kind of caption. Governor who forgot his job. Governor never forget anything. But issue is governor how he is using discretionary power in case of constitutional silence. If constitution is silent, does not mean Goa, Manipur, Karnataka, Maharashtra, like states, will reflect one decision from governor coincidentally in favor of one political power. And in Tamil Nadu, governor will take another stand. So constitutional silence regarding the discretionary power is creating problem in India. Despite the fact that gubernatorial discretionary power is still demanding categorical scientific interpretation. But one thing governor should understand. Under Article 159, governor is given responsibility to uphold the constitution. Governor is preserver, protector and defender of the constitution. Governor is custodian of constitutional morality and constitutionalism in this country at the state level. Constitutional supremacy must prevail. No one is supreme except Constitution. Our democracy will be healthy, our democracy will be qualitative when people occupying constitutional position will respond and respect constitutional morality and philosophy of constitutionalism. So, democratic principles of nation should be respected by everyone, whosoever occupying constitutional position. Does not mean rest should not. But whosoever occupying constitutional position, their responsibilities are more than others. Particularly President of India and Governor, who are under oath that they should preserve and they will preserve, they will protect and they will defend the constitution. They must come out with that kind of mindset to serve the country, to make country genuinely a democratic republic with all highest standard of ethical qualities, to lead country towards ethical governance. So, I will wind up with the conclusive remark that when we are discussing this issue, already matter is settled as far as Tamil Nadu is concerned. But it's my personal opinion and personal doubt that this is not the last one, because still we are not defining, or we don't have any defined format for governor to perform. So today or tomorrow, if another problem will occur, it will be personality of governor to decide, and again state will be in dilemma. State should not be in dilemma, and governor should respond and respect constitutional morality and philosophy of constitutionalism. So whenever this kind of question will come, again I will write whatsoever I had given you earlier. Governor, first of all we will go with constitutional provisions, then we will come out with whatsoever issues are there, then we will come out with what? Commissions, recommendations, then judiciary, and finally conclusion. Right? Apart from this topic related to governor, you will find in recent time period, governors did a very unique kind of thing, that was a situation very awkward when they took decision to boycott a one yearly ceremonial function that was addressed to joint sitting, and governors refused to read a speech prepared by government. In Tamil Nadu also it happened, in West Bengal, in some states it happened. Governors refused to read the speech prepared by government. You know that at national level also President will read the speech prepared by government. That is parliamentary customary provision. So governors also are expected to understand that India is running parliamentary system. We are under parliamentary democratic system, and there is not at all any provision of governor's imperialism or presidential imperialism. President and governors both are expected to respond the constitution. I will not use your books and other materials use nominal head, because there is no any word in nominal in constitution, and from my point of view that word nominal is a disrespect to the highest executive head in the country as far as the de jure head is concerned. But one thing is very clear, that president and governors are expected to play their role as per the aid and advice of their own council. Their own council, why I am talking about? Because they and they only constitute council of ministers. So they must respect their own decisions. And of course, if council of ministers is not performing as per president and governor, then constitutional provisions are there to dissolve council of ministers at state level as well as national level. So president and governor both should respond and respect constitutional morality and the philosophy of constitutionalism to strengthen the quality democracy and ethical governance in the country. Right? This is all about the governor. And now the second caption is public interest litigation, tool for justice or judicial overreach. Tool for justice or judicial overreach. This is a topic for us. PIL, public interest litigation. First, I will go for conceptual introduction. Conceptual introduction, and then why required Then problem areas, and finally conclusion. Okay. Conceptual introduction, that will cover historical part also. Why PIL is required? What are the problem areas? And one is finally conclusion. So PIL conceptual introduction. There is a word pro bono publico. Pro bono publico. Okay. Pro bono publico is maxim that is for public interest. Pro bono publico for public interest. Okay, for public interest. This concept was primarily originated in USA in 1960s, and there it is known as social interest litigation. In USA, it is known as social interest litigation. In India, public interest litigation. Public interest litigation has turned into a revolutionary judicial development in our country, which has provided legal remedies to deprived section of society. This concept has helped in establishing micro accountability along with macro accountability of governments. I will repeat. It has helped in establishing micro accountability along with macro accountability of government. Micro accountability deals with ethical and moral responsibilities. Macro accountability is related to legal accountability. the golden key to unlock the door of injustice. Golden key to unlock the door of injustice. In India, people who had money were in a position to approach judiciary. Have and have not, two clear divisions are there. People marginalized, people who were at the periphery, people who were deprived, were not in a position to approach judiciary, even to defend their own fundamental rights. PIL is incarnation of judicial activism to make judiciary people-oriented, to make judiciary citizen-centric, to make judiciary problem-solving in nature, to make judiciary capable to empower citizens to approach to judiciary to solve their problems. In India, the seed of concept of PIL was initially sown by Justice Krishna Iyer. Justice Krishna Iyer in 1976 in Mazdoor Kamgar Sabha versus Abdul Thai case. And after that case, Supreme Court became much more concerned about the public grievances particularly of those people who were deprived, who were marginalized, who had no voice, who were not in a position to come to judiciary. This new method of inclusive legal system was justified, and Krishna Iyer categorically stated that we are supposed to liberalize the locus standi of judiciary. It means the domain of judiciary should be liberalized. If domain of judiciary will not be liberalized, people, I will repeat, particularly marginalized, or people on behalf of marginalized will not come to judiciary. So judiciary will be confined in a very narrow area, and people having money will come and get justice, so called. That is not appropriate. Then one major case came, that was Hussain Ara Khatun versus State of Bihar, 1979. This was considered the first reported case of PIL. This case focused on inhuman condition of prisoners and under trial prisoners. But without any doubt, one can say the concept of PIL was blossomed in SP Gupta versus Union of India case, 1981-82. When P.N. Bhagwati laid the foundation effectively, P.N. Bhagwati and Justice Krishna Iyer two major contributors who expended the locus standi of judiciary. The landmark revolutionary initiative of PIL includes number of new things. India was not aware about it. The first one is the expansion of horizon. I am talking about locus standi. Innovative contents or components under PIL. The first one was the expanding horizon of locus standi. It means judiciary tried to touch the periphery. Judiciary tried to come to people who were in need. Second revolutionary and innovative method adopted, that was another very revolutionary epistolary method or epistolary jurisprudence. What is epistolary? postal letters were used. To file PIL. So this was another innovative component in judicial system. That postcard will be used to file litigation. It is called evolving epistolary jurisdiction. Evolving epistolary jurisdiction. Then the third aspect, socio-legal commissions of inquiry. Socio-legal commissions of inquiry. The fourth one, monitoring laws and judicial orders. Monitoring laws and judicial orders. And fifth one, enforcing public duties. So 5 components. First, expansion of judicial horizon. Second, new method going to evolve, that was epistolary, means using postal papers to file litigation. Third, appointment of socio-legal commission. Fourth, monitoring of laws and judicial orders. And fifth one, enforcing public duties. Now you will find that when you will talk about the first component is expanding horizon of locus standi. When Justice Krishna Iyer took that case, Mumbai Kamgar Sabha, he was very much concerned about the justice to the common man. There was a movie, Chennai Express. Don't underestimate the power of common man. Justice Iyer, I think, was talking about the same. And he was committed to ensure justice to common man. In that way, knowingly or unknowingly, Justice Iyer was transforming Indian judiciary to perform as a social auditor. Judiciary is expected to perform as a social auditor. When public interest litigation will be enforced, people will come out. Not only after considering their fundamental rights, but fundamental duties to respond on behalf of people of the country who are suffering. So judiciary will be duty bound to perform as a social auditor. In that way, judiciary tried to kick-start its new responsibility or new duty. When we talk about epistolary jurisprudence, it is very simple in one sense, that people who are enjoying power, people who have resources, people who are enjoying accessibility, only will not be entitled for justice. Supreme Court in Dr. Upendra Bakshi versus State of Uttar Pradesh, Professor Upendra Bakshi versus State of Uttar Pradesh, 1981. Supreme Court entertained a letter, I will repeat, Supreme Court entertained a letter sent by two professors of Delhi University seeking enforcement of constitutional rights of inmates. Two professors sent letter to Supreme Court seeking enforcement of constitutional rights of inmates of protective home at Agra who were suffering from inhuman condition. And judiciary responded that two professors had nothing to do with those inmates. But judiciary, after getting that information, responded proactively. Similarly, in Veena Sethi versus State of Bihar, 1982, Supreme Court treated a letter addressed to the judge of Supreme Court by Free Legal Aid Committee, Hazaribagh, Bihar. One committee, Free Legal Aid Committee, Hazaribagh, Bihar. That committee sent letter to Supreme Court, and later was considered as a PIL that was related to ACR case. ACR 1982, that was related to case article number 23 of the Constitution, bonded laborers. There was a case or complaint that laborers were not getting minimum wage. So they were forced to perform as a bonded laborers. That was Veena Sethi versus State of Bihar case. So Supreme Court accepted that later itself as a litigation. It is a new era of epistolary jurisprudence. Then I will come to the third component, that is appointment of socio-legal commission of inquiry. You will find Supreme Court took one another initiative. And it was the beauty of PIL era that Supreme Court was in favor of appointment of commissioners from among advocates, professors, magistrates, journalists, responsible citizens should perform as commissioner to know the social status of people. You will be surprised that one eye specialist, a group of eye specialists, were ordered to go to Bhagalpur in Bihar to report on Bhagalpur prisoners. That was a blind case. Hope all of you know Gangajal. That movie was based on Bhagalpur. So Supreme Court came out with appointment of a group of eye specialists to go there and to get the ground reality. Similarly, sociologists were sent as a commissioner to inquire into working conditions of laborers in a stone factory, Faridabad. So court tried to become a body with participatory management. Court came out with a philosophy, liberal and global, that court will not be confined to the courtroom or periphery of the courtroom or within the wall of courtroom, but common people also will be given responsibility to respond the justice. Their observation also will contribute a lot in judgment of judiciary. You will find Supreme Court took the responsibility of monitoring of law and of orders. You will find number of CBI cases monitored by judiciary. Supreme Court came out with monitoring. CBI will not perform alone, CBI will be monitored by judiciary. And public duties, of course. In article number 22, I want to recall you people. Article number 22 of the Constitution, there was a case, D.K. Basu versus the State of West Bengal, 1997. That was related to arrest. In that case, Supreme Court categorically stated that there will be a public duty of magistrate. Public duty is not expected to do whatsoever is doing. There must be appropriate public inquiry, only then the detained person will continue in detention. So there will be a responsibility of magistrate as a public functionary to perform duty with dutifulness. It means directly or indirectly, as far as the fifth component of PIL is concerned, four already, fifth component of PIL is concerned, it was leading judiciary towards one ethics called deontological ethics. Deontological ethics deals with duty with dutifulness. So public functionaries are expected to perform their duty with dutifulness. And D.K. Basu versus State of West Bengal 1997 was all about that duty with dutifulness only. So with these all five components, PIL came into picture, right? And formally we entered in PIL era, right? Now, as I told you, why PIL era began? Why we will support PIL? What should be, or what will be the significance of PIL? So I want to share with you reasons and significance of PIL. Okay. After that, I will come to present day problem. India is known for vibrant democracy. We are progressive. We are future oriented. We are welfare state. We want to be citizen centric. We want to be a birthplace of democratic republic, not in quantitative sense but in qualitative sense. As far as Indian Constitution is concerned, we have Article 21, 32, 226. Three major articles. Article number 21, Article number 32, Article number 226. Apart from that, DPSP and fundamental duties. These are the major provisions pushing us, forcing us to move towards PIL. Because India wants progressive social legislation. In preamble, you will find India talks about social justice, economic justice, and political justice. So we are supposed to introduce progressive social legislation. Being a mature democracy, we are expecting harmonious relationship between fundamental right and fundamental duties. Some of you may know, all of you, Supreme Court in Minerva Mill versus Union of India case, 1980, categorically stated that fundamental rights are nothing but mean to achieve the end that is given in directive principles. So mean and end both are important. If mean will be wrong, end also will be wrong. That was the philosophy of Mahatma Gandhi. So without disturbing fundamental rights, we are supposed to implement directive principles. So, progressive social legislation will demand harmony between fundamental right and directive principles. Right? It was a demand of the day. Then, as I told you, that India is the first welfare state. So, being a welfare state, we want to be citizen-centric. And if you want to be citizen-centric, it will be essential for you to address marginalized and poor people. Without this all, our fundamental rights, our directive principles will be meaningless. Without this all, you will find the preamble talking about social justice, economic justice, and political justice meaningless. Preamble of the Constitution talks about liberty, equality, fraternity, and dignity of individual. That also will be meaningless. So it was the demand of the day to go for PIL. And when we decided to go for PIL, these are the mitochondria, energy house, giving us energy to respond this all. And when we will respond this all, we will understand the significance of PIL. Getting my point? So why we adopted PIL? Because we were aware about Article 21, Article 32 to 26, directive principles and fundamental duties. These all were related with preamble of the Constitution. If India was ready to translate itself into a real welfare state, or if India was ready to ensure social justice, economic justice and political justice, it was essential for India to go for progressive laws. It was essential for India to go for marginalized or deprived people. It was essential for India to go for harmony between fundamental rights and directive principles without difficult to make fundamental rights and directive principles meaningful. So that's why PIL was considered very important. Now, you will find the significance of PIL. The significance of PIL will reflect the scope of PIL also. You will find PIL in India respond prisoners' right who are in jail. Okay? Prisoners' right. Sunil Batra versus Delhi administration. We are very much aware. That case came in 1978, and in Sunil Batra versus Delhi administration case, a prisoner who was lodged in jail wrote a letter to Judge Supreme Court complaining brutal assault by warden. And that letter itself was considered as a litigation. And Supreme Court used Article 32 habeas corpus to force executive to present that prisoner before judiciary. That was Sunil Batra case. I think in article number 32 you people have discussed it. This was Sunil Batra case. Similarly, in Prakash Singh versus Union of India case 2007, Supreme Court directed Union State Government to implement police reform based on long pending recommendations of expert committees. So prisoners' right must be given attention, and PIL became responsible for highlighting the problems of prisoners. Then you will find another problem, Article 23, bonded laborers, Article 24, child laborers. Bonded laborers and child laborers. There was a case, PUDCL, PUDR, People Union for Democratic Reform versus Union of India. And in that case, Supreme Court entertained a writ petition for the execution of certain labor laws. Apart from that, already I discussed with you Asiad case. So Supreme Court became concerned about proper implementation of Minimum Wage Act to address Article 23 and 24. So with PIL, we can address the problem areas related to children also. Then right to life. Right to life. Article number 21 of the Constitution is considered important always. I want to share with you only one case, that is Vishaka versus State of Rajasthan, 1997. Women also are entitled to enjoy dignified life like men. And at workplace, there should not be any kind of sexual assault. For that, Supreme Court came out with guidelines. So right to life with dignity, court considered, and that's why it became possible for the country to come out with Vishaka guideline to respond to women. Then you will find fourth one, environmental protection. Environmental protection. MC Mehta case, number of cases, Subhas Kumar versus State of Bihar, 1991 case, pollution-free water and air of full enjoyment of life was considered important. Then you will find another area that is called political corruption. That area is related to political corruption. Political corruption, I am trying to share with you that PIL is emerged as one very effective instrument to lead country towards good governance and ethical governance. You will find PIL was introduced to ensure accountability and good governance when Supreme Court came out with a very clear instruction related to petrol pump scam, related to housing scam, and very famous fodder scam that was related to Bihar. So, corruption cases should be addressed amicably. There was a Vineet Narayan case. Vineet Narayan case, very famous. Hope some of you know. That was related to stock market, share market. Former Home Minister Lalkesh Advani also was accused and he resigned once in 1991-92. Supreme Court responded that case very effectively to ensure corruption-free political life in the country. You will find another one is human right. That is very important. Human right. Medical treatment to person, immediate medical support to people. This kind of things became possible because of PIL. So in nutshell you will find PIL is related to vulnerables, PIL is related to workers or laborers, PIL is related to human right, PIL is related to people who are unable to raise their voice. I am talking about marginalized. PIL is related to good governance, accountable governance in our country. PIL is related to environmental justice. PIL is related to right to health, right to education. So number of areas and dimensions are attached with PIL. So without any doubt, PIL is the demand of the day. PIL is a strategic arm of legal aid movement. For people who reside in areas, so-called slum areas, or who are forced to live in lower strata of society. PIL is instrumental for social change. PIL is essential to protect human rights. PIL is instrumental behind opening the door of Indian judiciary for common people. So, PIL is the boon. It is the blessing of the God that force Indian judiciary to come out with PIL and Indian judiciary on right time came out with sound mind to introduce PIL. But unfortunately, during course of time, people of the country misused PIL. I want to recall the statement of Woodrow Wilson, who was of the view that sharpen the knife is not wrong, but intention behind sharpen the knife. PIL itself is not an issue. As we discussed, PIL essential for environmental protection, essential for health, essential for atrocities against women and all vulnerables, essential for human rights, including ST/SC and all, jail reform, labor reform. But unfortunately, scandalous PILs became a problem for the country. Frivolous PIL, wrong intention for publicity, we introduced PIL, that became a problem. You will find I want to share with you one data. One gentleman, he is very renowned advocate, known for PIL, Ashwini Kumar Upadhyay. He filed 150 PIL in 1 year, 2022. And many of his PILs were dismissed. Unfortunately, court continued to entertain his PIL. That is one another issue. Because courts are not uniform. I am talking about Supreme Court and High Court. Not uniform. 150 PIL in 1 year. Ashwini Upadhyay came out with. And very interestingly, the Delhi High Court Chief Justice D.N. Patel that time said, Mr. Upadhyay, how many petitions you have got typed in your drawer in printing? We will keep it all on October 1st. Whatsoever PIL you have, please carry all. We will discuss. But he was not given warning. If will not be given warning, PIL will become uncontrolled banyan tree. That will not be good. Over flooded PIL will squeeze the infrastructure of the judiciary. We know that judiciary is not getting sufficient fund. Indian judiciary is struggling for fund. Number of posts are vacant. If judiciary will come out with intentional, unjustified PILs, will come under pressure. I want to share with you one another fact, that 9,23,277 PILs were filed between 1985 to 2019. It means approximately 26,300 per year. In a country where more than 5 crore cases are pending, if PIL will be misused in that way, there will be a problem. And recently, our judiciary came out with heavy hand. Justice Nagar, who is one judge out of 9-judge bench hearing Sabrimala, said that PIL is converted into private interest litigation, publicity interest litigation, paisa interest litigation, and political interest litigation. All are called PIL. That kind of PIL will be curse for the country, although the concept of PIL is boon for the country. Going with that kind of observation by Justice Nagarthana, Union government said that PIL is nothing but agenda-driven litigation, and it is nothing but institutional overreach. So judiciary should wind up PIL regime. There is no any meaning of continuation of PIL in India. That is the stand of Indian government today. Judiciary should wind up PIL. It is meaningless, not essential. But Supreme Court is very clear that PIL is neither misused to that extent nor is judicial overreach. People who are charging PIL as a judicial overreach must understand that the center of gravity of justice, I will repeat, the center of gravity of justice is nothing but preamble of the Constitution. And judiciary that is responsible to be custodian of Constitution as per Article 124 of the Constitution is responsible to implement justice in real sense. Justice must be done, justice must be seen also. That must be visible also. So, access to justice is the fundamental right to each and everyone. Municipal Council Ratlam versus Vardhi Chand, case 1980. Supreme Court categorically stated that access to justice is the right of each and everyone. So people cannot be deprived. But at the same time, judiciary must come out with self-restraint. Judiciary must come out with self-discipline. And when judiciary will come out with self-discipline, it will be responsibility of judiciary to prescribe effective guidelines to check any misuse of PIL. It will be responsibility of judiciary to stop any kind of legal imperialism, judicial overreach that may go beyond Indian Constitution. Judiciary also is equally responsible to ensure constitutional philosophy in our country. So it is the first duty of judiciary to ensure let justice be done. And let justice be done will become reality when PIL will continue. But of course, with effective guidelines. And you will find that Indian judiciary in the state of Uttarakhand versus Balwant Singh case 2010, state of Uttarakhand versus Balwant Singh case 2010, came out with direction, prescription, and as per the prescription, one scrutiny committee will be constituted. The credential of litigant will be examined. High courts will be expected to come out with uniform laws to respond PIL's ineffective form. Supreme Court categorically stated that if anyone will come out with a wrong intention for publicity, or if any kind of luxury litigation will come, exemplary punishment will be given. And hope you know, Juhi Chawla was given punishment with a very hard-hitting words. So, public interest litigation should not be history. It should not be erased from the judicial canvas. It is very important to continue with PIL, and at any cost it should not be considered as the overreach, but of course guidelines which are prescribed by Supreme Court must be followed effectively. If these guidelines will be followed effectively, then people who are misusing PIL will be discouraged and will be penalized, and that will be an example for others. If PIL is misused, it does not mean PIL should be erased from the scene. Curative approach is required. If person will suffer from illness, even judiciary will not allow that person to die. In the same way, PIL itself is not curse for the country. People who are using PILs are responsible for making PIL wrong. So judiciary should address and should cure the disease rather than the person. So PIL must continue. PIL must be integral part of Indian judicial system, because that PIL only will be one effective instrument to make vulnerable to approach judiciary with accessibility. So the topic was a PIL, tool of justice or judicial overreach. In no way it is judicial overreach. Judiciary is responsible to understand the center of gravity of justice, that is preamble, and it will be the responsibility of the judiciary to respond Article 124 that deals with a custodian of constitution and law. So Indian judiciary is a disciplined judiciary and a responding PIL effectively. It is misused, it should not be, but it cannot be considered overreach. Right? So I discuss with you this PIL also. I hope things are smooth to go, and allow me to wind up. Next time I will come with another topic, right? Either in Hindi or in English, right? So this time in English, next time I don't know in Hindi or English, but hope you all are benefited, right? So thank you very much. Allow me to wind up. Thank you.